Good evening. My name is Bob Orzechowski. I'm Chief Operating Officer for Lancaster Cancer Center, and we welcome you tonight to Human Resource Management here on BCTV. It's a beautiful night out there. Tuesday, July 12th, 2016. We are live, and we welcome the home viewers out there with questions, comments, and gentle complaints. 610-378-0426. We are live tonight. And to bring on the panel tonight for our discussion, and we'll talk about the show in just a moment. To my immediate left is Christopher Holmes, Chris as he prefers to be known. And Chris is the HR director at the Highlands at Wyomissing now. Previously he had some 8 years in HR in the Lehigh Valley in a health system there. And he also has experience in safety and project management. Welcome, Chris, to the show.
Thank you, Bob.
Thank you. Chris is also a certified HR professional through the Society for Human Resource Management and is currently our Chapter 179 Secretary.
Correct.
Great. So he's on the officer roles. And to my far left, a frequent panelist here is Kevin Moore. He's an attorney with Leisawitz Heller. They have offices in Wyomissing and Hamburg. He's been with them 20 years, his entire private practice career. I think that might be a record somewhere.
Well, I don't know about that.
Well, Kevin chairs the law firm's Labor and Employment Law Division, and he's also serves frequently on the local bar association's Employment Law
Section.
Thank you. Sections, divisions. So we certainly welcome Kevin again.
Thank you.
And he's been, his area of concentration, of course, with the firm is the labor and employment law, and we could not have a program like this without his august counsel. So thank you for coming again.
Thanks for having me again.
And to bring it up to speed, this July, this is our 70th program, 11 2/3 years today. We want to thank the volunteers behind the camera and in the engineering booth, Josh, John, and Joan. Thank you so much for your able assistance, without whose help we could not even bring these programs to you. We also want to thank Mosteller and Associates. We have their information up on the screen at the top of the program, at the bottom of the program, and somewhere in between. Chet Mosteller and his fine firm of HR consultants and experts in all fields. They're out there at 2433 Morgantown Road, and their phone number you can see on the slides. Hopefully it would be 610-779-3870 or mostellerhr.com. And Chet's also been in the chapter for many years, up through the officer chain as well. So we encourage you, if you have an HR need, to reach out to Chet and Mosteller Associates. The program tonight, always full of surprises and controversy, employee rights and discipline. So home viewers out there, we are live tonight, Tuesday, July 12th, 610-378-0426, and we welcome your contributions. A little bit of a disclaimer that nothing here is meant to be legal advice, and the opinions of the panelists are our own and not necessarily those of our employers or of BCTV. Speaking of BCTV, some great developments here. We are international now. We're on YouTube. They've just started an app for your Android and mobile devices, Social Local, and they refer to it as SO.LO. Solo. I don't know if that means flying solo, Han Solo, or we're just solo. But we're not solo. We have a panel tonight. And so we're on that. Now, this particular show replays Fridays at 8, Saturdays at 1, and Wednesdays at 9 a.m. So no matter what shift you're working, you can catch the program. We want to mention the online streaming, bctv.org as well. And I don't know if you really don't watch a lot of television, but if you looked at the BCTV website and saw the vast array of programming they have, there's something for everybody. And It's a real gem in our community. It's unique in many ways to our community alone, enhancing the unity and strength of our community by providing these forums for the exchange of information, no matter how controversial. So, with all that, I'd like to move into the Society for Human Resource Management, just briefly, and Berks County Chapter, who we are, what we do. And I'll turn to Chris first because he's been in the chapter a while and is now a newly minted officer. So, Chris, can you tell us a little bit about the chapter, what we do, benefits of membership, why should people join?
Well, first of all, it's the best way to stay current and educated in the human resources field. For me personally, networking with other professionals in the field is always great for career information, career advancement, if that's what you're looking for. Definitely come out. You can come out as a guest initially, get a feel for it, and I wouldn't be surprised if you become a member shortly.
Okay, and Kevin, I know you attend many of the meetings, and as an attorney, especially with the focus in HR, what's your take on the general monthly meetings?
I think the general monthly meetings are an excellent way to stay current on the hot topics. Our chapter does a fine job of getting the most important topics out in front of the professional members as soon as possible. That helps me to help my clients when I go back to the office if there's something new that I hadn't heard about, and typically we try to bring in experts in the field, in the subject matter, if you will, subject matter experts. That's great one-stop shopping for all of us members, and we get to a breakfast meeting, we get to meet and greet other members. I often and always recommend to any of my new clients that their HR professionals join our chapter. It's going to help them. The resources both locally and on the national level with SHRM are just a fantastic supplement to their departments.
Great, well thank you. We will have it at the bottom of the show tonight. We will produce the ways you can contact our administrative director, Wendy. We'll have a telephone number, there's an email address, and a website. We welcome, here it is, we'd welcome your kind attention to that. The Society itself is an international organization. Our headquarters are in Washington, D.C., Alexandria to be specific. About 200,000 members in maybe 100 countries worldwide. And we are an affiliated chapter with the Society. But you don't have to have HR in your title to be in the Society or to be in our chapter. You just have to have HR responsibilities of some professional level. Excuse me. But we also we have people in a wide array of, as the industry has changed and the profession has changed, there are many employment firms there. Several attorneys, of course, and there are people who provide services to the HR profession, such as consultants, payroll companies. We just had a fellow today from a payroll company join us. And if you're in many of the state agencies, we find their members coming as well. Our meetings are monthly, the second Tuesday of every month. It's always a breakfast meeting. And we meet out at the Berkshire Country Club the second Tuesday of every month. And if you need to come out and be a guest of one of the members and see what we're about first, to kick the tires, that you're welcome to do that. Our meeting this morning was a presenter from the Drug-Free Workplace organization going over the various and sundry issues about workplace drug and alcohol abuse issues and policies for that. It was very informative. And that kind of leads into tonight's program. But we also, for the chapter, we have a certification committee where we will run study groups for any members who wish to become certified. We have a diversity and inclusion committee that focuses on those very issues with area employers. We also have, every December, we run a dinner and holiday party for the children down at the Police Athletic League, which is always well attended. We also sponsor a student chapter at Alvernia University. So we're not just a pretty face. We really do some things out there, in addition to bringing this show to you bi-monthly for the last 11 and 2/3 years. Let's move on to the topic for tonight, employee rights and discipline. Now, what you're going to hear a lot tonight is, well, it depends. Is it a private sector company or a public sector company? Is it union or non-union? We might slay some sacred cows tonight. What rights do you really have out there as an employee? We also want to educate employers as well, so they don't stub their toes and need Kevin's services more than they would need to. Let's start off with Kevin, if you would, a little bit of legalese maybe, statutory rights, contractual rights, common understanding rights. Where do we begin?
Well, I think we should begin, Bob, actually at the level of, and I'll deal with Pennsylvania law, the common law doctrine of at-will employment, because I think that forms the basis of our discussion this evening on the rights. And that doctrine very simply states that under Pennsylvania law, an employee or the employer may terminate the employment relationship for any reason or no reason, so long as there's not a violation of statutory rights that we'll get into in a few minutes, or some what we'll call the common law public policy exceptions to that at-will doctrine. That's an important premise, and on every phone call I get from an employee who has concerns about the workplace, we begin there, and it's really the focal point for the analysis to begin. So from the common law doctrine that an employer can terminate an employee merely because today's Tuesday, July 12th. That is perfectly legal under the long-standing notion of the at-will doctrine. Then the onion skin needs to be peeled away a little bit further and say, okay, are there exceptions to this doctrine that may apply? And we have a list too long to recite this evening on statutory rights, and the most important of which are of course, your civil rights that come from the Constitution, and that would be the statutes and laws that protect what we call protected characteristics, your age, your race, your religion, the big ones that we all know about. Those are the biggies, but there's also others. For example, USERRA, the military service law that protects an employee at certain levels. Mm-hmm. And there are other statutes that may apply to an employee, and again, as we discussed, possibly if they're a public employee or if they're not a public employee. Or there may be contract rights. They can be individual contract rights, or they can be collectively bargained contract rights, aka a union setting. So that's the second level of analysis that we always go through whenever a client or a potential client calls us, either the employer or the employee.
You have to frame the issue first.
Absolutely, or else you're talking in circles.
Yes.
So the statutes are the second level of analysis, and then the third level of analysis, as I mentioned, would be whether there's contract rights involved, either a private written employment agreement that provides for a term of employment and certain conditions that allow for termination, or a collective bargaining agreement whereby members of a union give to their union leaders the authority to negotiate the terms and conditions of employment, and that is obviously in writing and negotiated between the employer and the bargaining unit.
Well, the at-will employment is a very interesting concept with a history that maybe has been lost to the fog of time. But prior to the Civil War, prior to the Industrial Revolution, there was really no national employment policy. People came and went, and then we had massive need for massive manual labor, and nobody could really figure out, well, under what conditions. It's not an apprenticeship where you're going to work for 7 years for basically room and board and then go out on your own. There were no relationships to speak of, and an attorney with the last name of Woods modestly propounded Woods' rule, which was to say the at-will relationship. People could work where they wanted to and stop working there when they wanted to, and employers likewise. And neither was terribly advantaged or disadvantaged in the deal. Well, of course, today most employers have the upper hand, and thus so many of the laws we have, I think. And it's interesting that we've kind of gone full circle from back then, employment at will, to today. There are many, many restrictions on the concept, and we're going to discuss a lot of those today just because. But when we mentioned public and private, in the public sector, there actually are constitutional rights that may not exist in the private sector, and I think that shocks a lot of people to think that. Maybe, well, it's coming up to election time. Could you comment maybe on all the election discussion and topics and button wearing and whatever in public and private?
I'll do my best.
Okay.
Because now we're going to get into a separate set.
Because then I'm going to ask Chris how they do it there.
We'll get into a separate set of rights under the National Labor Relations Act and the Pennsylvania Labor Relations Law. When it comes to politics and free speech, which, politicking and the notion of politics is generally understood to be involving the exercise of free speech. And in the public sector, the employees have a certain level of rights. In the private sector, employers had a stronger hand historically on regulating what we'll call that free speech right in the private workplace. That's something that has actually become much more level in terms of the public-private dichotomy lately, because the NLRB's recent interpretations of the law have broadened the protections for employees to discuss terms and conditions of their employment in a manner that also protects free speech. And so that is not so much of a difference anymore with public and private sector relationships in the workplace when it comes to politics. I wanted to mention when it comes to the NLRB and the National Labor Relations Act, the fact that the statute's called the National Labor Relations Act makes most people conclude that it only applies to union workplaces. And that's not true. That law applies to union and non-union workplaces. And it's a very important distinction. And it affords protections to employees through interpretation that has changed over time, and has actually broadened the rights of private sector non-union employees to engage in more free speech that their brethren in the public sector have historically had. Okay.
Chris, and I know we're putting you on the spot a bit here, but that's why you're here. It's the danger zone. But have you had any issues now that it's coming into politics season? Have you had to issue any dictums, rules, elements of decorum with water cooler conversations, button wearing, leafleting, or anything?
No, actually, Bob, because we've had a long-standing established policy of not allowing folks to wear pins, and it's basically based on policy, what's most fair to everybody. So it's like in our case, it's all or none. Do we allow everybody to promote their causes and beliefs, or do we limit that to just a small break room conversation on their own time? And that's been very successful for us.
Okay. We'll get into something here with maybe slay a few sacred cows or spike a few rumors. What's the policy at the Highlands on things like work breaks? Because I don't know if Kevin's going to have any input here about, obviously in transportation, you can only drive for 10 hours and you can only fly for whatever, but...
Well, in our environment, it's a 24/7 environment, but we do promote a 30-minute break for every full-time shift that they have. We encourage that. We know it's not required by law, but we really want them to have that break. It is an unpaid, unless they do not get an uninterrupted break time, then we'll pay them for that. Because a nurse, for example, may get called out of his or her break time, and we would have to compensate for that. But normally, most of the time, it is an unpaid break time. They do get also some break times, a 15-minute break time here, paid 15, maybe a morning or an afternoon 15-minute paid break, but that's based on operational availability. If it's not an entitlement, if they can take it, great, and for the most part, we hope they can. But under some circumstances, they may not actually be able to get a paid break every once in a while.
Now, where does that fit in with the nursing mother law? Don't you have to give them time to do that?
Well,
Sorry, I'm surprising you on that one, but it just dawned on me when he said that.
well, your question assumes that there's a lot of nursing mothers at the Highlands, but I hope you're referring to employees, because I would assume
Well,
there
yes.
wouldn't be a whole lot.
Oh,
of
yeah, we're
residents.
talking about employees.
Thank you. Now, the nursing mother law I haven't had to interpret or advise any employer on, and historically I represent employers in that instance, but it derives out of the condition of the mother related to their recent pregnancy. It's been expanded to be a separate standalone statute, and it would be an accommodation that an employer would have to make for the nursing mother. That's under federal law. I don't know if Pennsylvania specifically amended the Pennsylvania Human Relations Act or has a separate standalone statute. Generally, though, the Human Relations Commission in Harrisburg will follow federal legislation, but I'm not aware of a specific state law. I could be wrong on that.
Yeah, it's, well, and I'm sorry to have sprung that one on you. Normally, we try to prep for these, but when he was saying about no mandatory breaks, but anyway, and we talked about politicking, something that's always seems to be a touch point, especially now in the summertime, dress codes. How are you handling dress codes there? And then we'll get to Kevin with the way it should be done.
For a majority of our departments, there's a uniform which takes care of that. It's all automatically standardized. In, I would say, administrative type offices, we do have to give some guidelines. We actually have during the summer in our monthly newsletter for the employees, we actually show examples of appropriate business attire and what we would consider unprofessional attire. So we sometimes have to get to that point because individual judgment doesn't always prevail.
And Kevin, is it where with the Fair Labor Standards Act and the Pennsylvania similar law with a professional exemption? In HR, we like to refer to certain styles of dress and manner of dress as being professional or not, even if it's for non-professional people. So we're kind of misusing the word in a way, but where does dress code and dress policy fit in with employee rights and discipline?
Well, it's an important policy for the employer to spell out for its employees, and I'm getting right to the handbook, okay? The handbook is the Bible that establishes the policies of the employer, and if you're going to be engaging in standards of professional attire or casual attire or business casual attire, whatever the label may be, then you do need to draw those lines for the employees so they have an understanding of whether they're crossing it or not. Even sometimes, as Chris mentioned, to come up with visual examples. My law firm is a very professional environment, and our clients perceive that they are expected to, they're coming in to see their attorney, and so we have probably a more conservative and more stringent professional attire requirement for our employees, because they will from time to time directly interact with a client, not just the attorney. So it's important in my office that we spell that out, and as with any employer, I would recommend a clear policy that is explained, and that the employer should reserve unto itself the discretion to alert the employee that their attire is not appropriate on that given day, and have the right, and give itself the right, and let the employee know that the employer has the right to send them home and change. And also, even to that extent, to do so on their own dime, on their own time, to clock out and clock back in. That's an important tool, and that makes people think twice about whether the outfit they're about to wear or whatever is appropriate or not, and that maintains the standard of decor that the employer is trying to establish.
And I guess the safety zone there, we're talking about the danger zone, the safety zone would be if the employer can tie it to a business necessity as best they can, and not just, I don't want anybody wearing jeans because I don't like jeans. not good enough, is it?
Well, let me turn it around the other way. The free speech has not extended itself to the dress code yet.
In private sector.
In the private sector. And the standard or the bar for an employer to have a requirement, whether it's uniforms or professional dress or the discretion to send people home, is very low. That's something that I don't see a lot of. I get it sometimes actually in the healthcare industry where employers may want to require employees to cover body art or piercings because there's a sanitary issue associated with the work. And I see that from time to time. You know, you're in the healthcare profession, as is Chris, and I see that come up from time to time with my healthcare practitioners who are also employers.
Okay. We're getting into the weeds in a lot here. By the way, I want to let people know we are live tonight, Tuesday, July 12th, 2016, in case you didn't know that either. 610-378-0426, so we welcome your questions and comments and general complaints. I don't know if we can make a distinction between public and private in this. Certainly we can union versus non-union settings, but the concept, when some of these things might run afoul or conflict or whatever, the concepts of just cause and due process. And where do they fit into this? Because we like to think we're a fair people. And where does just cause and due process fit into rights and discipline? Where's the nexus?
When I was preparing for the show tonight, I looked at the definition, and just cause is a loaded phrase, and it is a term of art specifically derived from federal labor law. Okay, so that's important for the viewers to know. Just cause is a phrase that you will see in every collective bargaining agreement, and an employer has to have that burden, has to carry that burden of just cause for terminating the collectively bargained employee. That is the sacred cow, if you will, of the union represented employee. Sure. And not necessarily a bad idea either when you think about it. and that is well above the at-will doctrine. You can't say it's Tuesday, July 12th, you're fired in a just cause employment setting. And again, that would show up in the collective bargaining agreement. Now, conversely, the due process notion that arises out of employment, there is no due process in private sector employment, but the due process...
Mandated.
Correct. But the due process notion does derive from public employment. So when I discuss with either a public employer who I'm giving advice to or a client who calls in an employee who is employed in the public sector, we're discussing the fact that they have a slightly stepped up legal basis above at will as a civil servant, okay, employed by some branch of government. More often than not, they also may be a member of a union and have a collective bargaining agreement. So it's important to ask those questions as well. But in the private sector, just cause is a best practice. And when an employer is thinking of terminating an employee, they think along those terms, and that's okay. They don't have to. The law doesn't require it. And I often find myself advising employers, okay, why do you want to terminate this employee? Well, here's the reason. Do I have just cause? Hold on. Do you have a collective bargaining agreement? Do you have a written contract that says you need cause? If you don't, we can start from the at-will doctrine and move on from there. But it's a best practice, I'd say. Would you say so, Chris?
I agree with you, Kevin. Indeed. I've been following that practice for over 8 years now, and it's served me well. Even in some cases where I may felt we didn't have to, it really does, in the long run, I think it's best to follow that best practice.
It simply is enlightened modern HR management in that sense.
Sure.
So, Chris, at the Highlands at Wyomissing then, can you give us some examples of how you're weaving the concept of due process? And do you have an ombudsman? Do you have alternative dispute resolution panels? I mean, how do you let people know that, hey, we're going to be fair here. You might not like the outcome, but it's going to be fair.
Right. Well, I try my best to be the mediator wherever I can, and that if the employee is, I'd say, not satisfied with the outcome of a decision in that matter pertaining to them, they know they can go through what we call a fair treatment process. It's our homegrown hearing process, if you will. So I will put a small team together with a formal hearer. Usually it's an executive member on our organization to hear the employee's case and also hear the manager in that dispute and make a decision. And that can go various levels through senior leaders or even a panel of hearers of
It's like the 7-step process.
Very similar.
Yeah, okay.
Yes, it is.
That's
very
okay.
similar.
And now we're getting mainly, we do have a show we do on discrimination, retaliation kind of things, and something that it's an important, subtle but important difference. And Kevin, if you could articulate about it, disparate treatment versus disparate impact.
Okay. This is a concept that comes up often in litigation, where the disparate treatment theory, it's a theory of liability, and an employee who suffers an adverse job consequence may bring an action, either formally or informally, and they're alleging that they were subject to discrimination because of disparate treatment. Because of a protected characteristic, they were treated differently than someone who doesn't have that protected characteristic, okay? And therefore, a statute was violated, their civil rights were violated. That's disparate treatment. Disparate impact is when you have basically the application of a facially neutral policy, whatever it may be.
So no intent.
Correct. Disparate impact, but disproportionately and negatively affects persons or the individual in a protected class. Most recently, the EEOC was publishing some of its data on background checks and the disproportionate levels of the populations of the African American community and Latino community who were suffering job denials based on background checks, and it had to do with a lot of statistical
Credit histories,
data.
driving histories, criminal histories.
Well, it was criminal. This particular
was.
statistic was criminal, and it went into great detail about the, this is obviously a very important topic right now as we discuss what's going on across our country, but discussing the populations that are involved and, you know, how many African American men or women are arrested and have convictions versus Latino versus Caucasian, etc. And those statistics are out there, and the more statistics you gather, the greater likelihood is that you could formulate a disparate impact theory where there is no intent on the part of the employer.
And where that fits in for the audience, as we get into these rights and employer policies, the employer necessarily tries to enforce the policies and apply them. And the key is to apply them in such a way that there is no, in fact, disparate treatment or disparate impact. So there was the fit. A little bit more about employee rights. Pennsylvania, I don't think it's federal law, but you can correct us, but Pennsylvania does have a law about employees being able to access their employment file or files, however many we have to have, just as the HIPAA laws and other federal laws for your medical record. You have a right to that, to see that, and to even possess it. Pennsylvania doesn't go quite as far as letting you possess it, although that's up to the employer. But what about the employee out there? Can they see their HR records?
While they're employed, the employee can see their HR records. The employer has the right to have them supervised while they're reviewing the records. They may not, the law does not require the employer to give them a copy of the personnel file. Personnel file is company property. But the employee may, or the employer may allow the employee to make copies.
Okay, and there are some restrictions. I mean, if the employer paid for certain tests, references that might have been given under the aegis of confidentiality, those things don't even need to be shared, do they?
No, there's limitations.
There's limitations.
Investigative files, by way of example, do not need to be shared. If there's anything related to a subpoena response or anything that's outside of the generic file, the employer has the right to state an objection, withhold it, and by and large, we don't see a lot of that. Employees think and they hear that they may have this right, they may not, so we get phone calls on it. But by and large, I think most employees understand that that's company property, and most employers are very cooperative with showing the file. Where it gets a little bit tricky is if the employee says, I'd like to see my file. Okay, they may be shown their official personnel file, but they work in a department where a supervisor may maintain their own files, and that might not get disclosed only by circumstance. The employee may not realize that there's more than one file. And oftentimes, the proof's in the pudding. If the employee thinks something nefarious is going on or their rights are being violated and they want to check, I've seen where the generic personnel file is presented and there's other information, if you will, contained in working files or supervisor files. Employers have to be careful about that.
So, Chris, how are employee files and records and how is all that managed for a population as vast as yours?
Well, I do my best to let the employees know there is nothing in their HR file that they wouldn't be aware of or even signed for the most part. I find in my experience, if an employee wants to see their HR file, it's because they have some suspicion there may be something in there that they don't know about. So I have no problem meeting with them. We go through the file. Most of the time, what they think is in there is not. So I'm not really sure where they would, perhaps they think their supervisor slipped something in there, but
do you
we
allow
don't allow
supervisors to keep their own little private files?
Well, actually,
Maybe
yes.
for memory jogging or something, anecdotally, but...
Yeah, some things that it's not as robust, doesn't include as much as our HR file, but they may.
A topic that always comes up, it seems, off-duty behavior. And again, with the NLRB and some other issues. Kevin, what are some of the real snakes in the grass with off-duty behavior? What can an employer do if they find out that a few of their employees are now moonlighting as exotic dancers?
Well, again,
For example,
it depends. In the private sector setting, assuming we're dealing with the at-will doctrine, an employer is free to make a determination. And let's assume under that set of facts, the employer simply states, I'm going to terminate these employees. Okay, there's no violation of any civil rights engaged there. There's no protected characteristic that's being violated under those facts, and the employer has the right to do that. Okay? Now we'll overlay that hypothetical with the application of the National Labor Relations Act. You said, by way of example, those employees. Well, let's say those employees were discussing how rotten the boss is and that they didn't make enough money, so they had to become exotic dancers. Okay.
Protected concerted activity.
Now they're engaging in protected concerted activity. They may have used social media to discuss it. They don't have to, but they might make a claim, regardless of whether a union or not, it does not matter, that what they were doing was protected activity and the employer terminated them in violation of those Section 7 rights under federal law. So the employer has to be very careful. It is good to contact your attorney if you don't know, and run the facts through them if there's a question mark.
Chris, do you allow off-duty, and any constraints, do you allow them to work in other jobs in addition to working at the Highlands at Wyomissing?
Yeah, we do ask employees that have other positions or any type of activity that's their own business, that it doesn't interfere with their work quality, performance. They come to work alert, didn't do their job well during the time frame that they're with us. So to that extent, I would, if I had some suspicion that some outside of work activity was interfering with their ability to do their job well, I would investigate that with the supervisor and the employee and try to come to some agreement.
Okay. A little bit about English-only rules. I saw something the other day in one of the professional emails that come around. Is there a line? Is it a narrow gray line or a bright wide line with we're a predominantly English-speaking country, and if the employer's business involves other cultures and other languages, you would want them to actually have multilingual employees. But where does English only fit into employee rights concepts?
The connection is that the non-English speaking employee who is required to speak English in an English-only environment might allege that they are suffering discrimination based on their ethnicity, their national origin, their race, which is tied to their language. And that's the legal connection, that's the nexus, if you will. However, when you get to the practical end of it, the business side, if you will, these requirements in this day and age with multicultural workforces are pragmatic. Most times they're safety-oriented. I represent a warehousing company that had some non-English speaking employees, and there was a dramatic accident whereby two non-English speaking employees couldn't communicate the emergency to the management, and there was a severe injury that occurred. And I won't get into all the detail, but the point is that's a reason and that's a justification for having some ability. It gets scrutinized, don't get me wrong. In other words, are there other mechanisms by which the employer could focus on safety and enhance employee safety without requiring English only? And the Equal Employment Opportunity Commission will quiz you as an employer if you have an English only rule, and they will typically give you guidance, give you recommendations, and maybe even file a claim if they believe that the English only application of the rule is discriminatory in its application.
Chris, do you have, obviously most employers I would think would want bilingual employees anymore in today's day and age. Do you see English only, and even if not just English only, but literacy issues? Do you see any of those kind of issues at the Highlands Wyomissing? How do you handle them?
No, in the past we had issues with electronic training systems being only in English, but over the past few years they are almost all, you get to choose the language you want to have the education in, so that's helped tremendously with us. And yeah, I do see having diverse workforce very advantageous. If you're in a healthcare setting, for example, and your clientele patients come in that don't speak English very well or it's their second language, it's wonderful to be able to go to an employee and say, can you help us out here? Can you interpret for us? Yeah, it's a wonderful resource.
Okay. We're about 15 minutes away from the end of the program. Tuesday, July 12th. It's just about 6:44, and we are live tonight, 610-378-0426. The subject, employee rights and discipline. This isn't 1984 anymore. It's not George Orwell, but can we talk a little bit about workplace monitoring, investigations, surveillance, and testing? I know we've, in the healthcare field, we've had patients come in and they've wanted to be able to record the time with the physician, either to share with their family when they go home, or, they don't have medical degrees, so they got to capture this somehow. But Kevin, can you frame the issue of workplace monitoring and surveillance? What's allowed, not allowed? Obviously there's federal wiretapping. Where do we fit with employee rights and workplace monitoring?
Employees are getting greater and greater rights. The expansion of rights is occurring under the last two presidential administrations at the federal level, because the National Labor Relations Board has expanded its interpretation of the law to allow for, by way of example, the use of company email for union purposes or discussing terms and conditions of employment on non-work time. The analogy is that the email system in social media is the modern-day water cooler, and therefore employees should be able to use these devices on non-work time. I want to be clear about that.
But company equipment.
Company equipment, but non-work time, notwithstanding a company policy that says you shall only use the company's electronic systems, computer systems, information systems for business purposes only. So that's actually expanding under the present interpretation of federal law. That can always change if federal administrations change, but for the time being, those rights have actually broadened. Now, an employer can still monitor email. It owns the system.
Not intercept, but monitor.
But monitor.
Okay.
And it can take disciplinary action. I just represented an employer the other day in an employment case where employee using email called their boss dumb as rocks. And the email trail was picked up and audited and will be utilized by the employer in defense of whatever legal action the terminated employee uses. So that's an example of where the employee's personal use, it was a personal, it was an email to a fellow employee, but on work time, and that can haunt the employee. As much as the expansion of the rights is existing, that's kind of a noose around their own neck too.
Chris, at the Highlands at Wyomissing, obviously employee and resident safety is paramount. Where does monitoring and surveillance kind of settle in there?
Well, I don't think anybody would be surprised at the Highlands, either resident or employee, that we have at least 35 cameras. We don't hide them. They're out in the open, inside, outside the facility for that very purpose. And so I think there is a comfort with that, and in general, I think people are okay with surveillance cameras.
Do you have signage everywhere that says?
Not necessarily, but we make the cameras visible. We don't hide them, and I can tell you that they're not in like lavatories or changing areas.
This
of
is
course.
video only.
Correct.
Now, but in the public sector, Kevin, would your answers be a little bit different as far as surveillance and monitoring and all that?
Well, with respect to the public sector, you know, you're talking about whether or not there is a right of privacy from the government as the employer, and there may be a heightened privacy right for the public employee, but the employer has the right to, by way of example, designate that there is no you know, locked drawers, you can't keep things in your office that you don't want us to see. Yeah, no, I'm talking about in the public sector. They're still allowed, the employer is still allowed, the public employer is still allowed to enforce levels of monitoring of the employee. You don't get much difference, really, Bob, between we'll call it the absence of the right of privacy. What we say in the private sector is that no employee has any reasonable expectation of privacy.
That's in my manual.
Right, in the workplace, and that includes the parking lot. If you don't want your employer to know about something, don't bring it on the property, period. But that can be waived, if you will, and the employer could unintentionally or intentionally grant a right of privacy by giving people lockers that they can lock, giving employees desks that they can lock, giving them spaces that are their own. Okay, and that's where a lot of my clients sort of stub their toes, because they're giving that right of privacy away, and they have to recognize that they may not have the right to interfere with that. And we get into, you know, those issues come up a lot in workplace investigations. When it comes to monitoring, in terms of public employer versus private employer, again, you're talking about whether or not there's a collective bargaining agreement. Publicly employed persons don't have much different privacy rights in the workplace.
Chris, I know in healthcare, maybe the concept of employee testing, maybe substance abuse testing, other kinds of testing, maybe in healthcare it carries a greater importance than maybe in some other industries. Don't know, but what sort of testing, employee testing, substance abuse do you have for cause? Is it random? How does it work?
Well, all new hires go through the pre-employment testing, and from there, because we're not a trucking company or a manufacturer, we don't do a random drug testing, but we do for cause.
Okay. I assume being in healthcare, we're sometimes a more kinder, gentler employer. Do you have an employee assistance program?
Yes, and we have 24/7 supervision, so if we suspect an employee didn't come to work fit for duty, we will send them over to our occupational services to be evaluated.
Okay. Kevin, I guess in the 5 or 6 minutes we have left, we haven't this was employment rights and discipline, and we focused heavily on rights. We really haven't gone into discipline much. The model I've come to use over the years, coaching, counseling, discipline, and then in discipline, depending on the offense, verbal warnings, written warnings, whatever. For the employers out there, what are some good pearls of wisdom to keep things moving forward instead of letting them break down and crash?
Be painfully fair to all your employees. I always apply what I call the double D rule, and that is, like yours, discipline and document. Because it's important to call out the employee when they are violating or nearly violating a workplace rule. Almost all of my clients, Bob, have handbooks with detailed progressive discipline policies and detailed descriptions of inappropriate conduct by way of example, but not limited to, here are all the things you should and should not do. And those are all well and good, but only if you enforce them, and only if you enforce them evenly. By way of example, just had a recent case where employee got terminated for what amounted to a laundry list of 15 or 16 items that the employer put in writing over the course of a month and a half, but not a single incident of coaching, counseling, or warning. And that's a problem for the employer. First of all, it's a challenging way to administer an HR policy. They had some mitigating circumstances. It was a brand new boss, head of a department that was trying to gel the team and didn't want to come across as too hard-nosed. But you know, you have to discipline and you have to document it. That way you have maximum discretion as an employer with what to do when it's time to pull the trigger.
Chris, I guess turning to the Highlands at Wyomissing, I imagine you go through a lot of supervisory training so that they don't crash and burn when the time comes. How does that work?
Oh, I would imagine the managers at the Highlands heard me say at least 100 times that I prefer corrective action over the term disciplinary action. Well, obviously, they're interchangeable, but it's the spirit in which the managers need to deliver the disciplinary action is in a spirit of corrective action. What is it you're not satisfied with? What are the expectations? Clarify them and explain why that employee needs to meet that expectation in a corrective way.
Yeah. I guess one of the standards I like to use is good surprises are always nice, but an employee should never get a negative surprise. They ought to know it's coming.
Right.
That's a good notion.
Well, any words of wisdom, I guess we can impart here in the few moments we have left. Document. Have your policy manual reviewed regularly by your attorney, because times change and laws change and case studies and it all changes. How do you? I mean, you can't just make it once and put it on a shelf. Be sure all the legally required notices are visible and not stuck behind a refrigerator in the lunchroom. So with that in mind, we have to bring this program to a close. And I certainly want to thank Mosteller and Associates, and their information will be up at the end of the program, our underwriter. And we certainly encourage the employers out there with employment needs and HR needs to contact Chet out at Mosteller and Associates. Certainly want to thank the chapter, Society for Human Resource Management, Chapter 179. For those of you with HR responsibilities, even if you're a small business owner, you have them whether you know it or not, to please look at the information at the end of the program here. Berks Chapter 179 at gmail.com is an easy way to reach us. And certainly the people at BCTV, Josh, Joan, and John, the 3 J's tonight. It's unusual. We don't always have that. Bringing the program to you here, manning the, or staffing, I should say, the engineering booth and the cameras. And certainly Chris Holmes, the HR director for the Highlands at Wyomissing. First time on the panel, and you've done fine. Thank you. We're happy you back.
Thank you for having me.
And certainly Kevin Moore, the chair of the Labor and Employment Division of Leisawitz Heller, with offices Wyomissing and Hamburg.
That's correct. And my marketing executive will want to correct me and tell you it's a practice group. So we have these fancy phrases.
Oh, is it, well, see, a division makes it sound like this massive conglomerate, you know. But
thank you for having me again, Bob.
Certainly, and we will be on again the second Tuesday in September. We generally, September, we try to have a legal update. There's constantly court decisions coming out from the county court, the court of original jurisdiction is what it's called.
It is.
Okay.
You know your history.
Well, it's my paralegal coming out from many, many years ago. And all through the state appellates, and then, of course, the federal district courts, and even the Supreme Court. Maybe we'll get a decision or two out of them this year yet. Who knows? So anyway, September we have that program, and November we don't know yet. But if you have any ideas, let us know. You know how to reach us. The program is replayed Friday at 8 p.m., Saturday at 1 p.m., and Wednesday at 9. And again, there's an app now, Solo, S-O-L-O, it's social local, and we're also on YouTube. So with that, I'll thank the panel tonight, and we'll look forward to having them on again, and good night.